So dears, we have seen till 130. We said that 100 to 130 was major, and some 2-3 points which were out of the reach, we did not bother too much. Now let's go inside and see what is there from 131 for this session. The person providing necessaries to minor is entitled to be reimbursed from minor's property. What is this contract? There is a contract called quasi contract. It looks like a contract, but it is not a contract. I will again repeat. Quasi contract looks or resembles like a contract, but it is not a contract. Now you cannot enter into a contract with minor, but you can reimburse from the minor's property. It looks like a contract, but it is not a contract. Are you clear? So I am marking this in the green color as usual, and we can accordingly go to the next level. The country with the resident of enemy country is void. This is a very simple point. So we know that it is not enforceable in the court of law. All the agreements in restraint of trade are void. Does not apply to sale of goodwill. Sale of goodwill is not going to be a problem in restraint to trade. If I am willing, I can sell my goodwill. I am not going to restrict anyone, and it is not going to be void at all. So this is valid only. So sale of goodwill, what I'm writing is valid only. Are you clear? Next, silence does not amount to fraud unless silence is equivalent to speech. The last sessions also we were talking about something called silence. Now, usually when somebody is asking you a question, if you are silent, that means you are doing some fraudulent activity. Now, silence does not amount to fraud, they are saying. Why they are saying like that? Instead of being silent, if it is equivalent to speech, if you wanted to speak, but if you are silent, it is going to be okay. That is not good. What does that mean? They are asking you a question. If you are silent at that time, then it is fraud because it is equivalent to speech. See the point here. Silence does not amount to fraud unless silence is equivalent to speech. That unless is the word you need to be careful. So when silence is fraud, if they ask you a question, when it is equivalent to speech. Very important question to be remembered. Silence does not amount to fraud. Okay. But when it is fraud, when silence is equivalent to speech. Are you clear? What is the meaning of consensus ad item? Meeting the minds of people or agreeing upon the same thing in the same sense. Unsound mind. Will you contract? No, it is void. Coercion, undue influence, fraud, misrepresentation and all is voidable. Next, A tells B that he will file a case against him for theft. B tells to A that he will give half of the market price. Already this fellow is doing a theft. He is giving percentage and they are doing in a partnership way. Is that valid? Definitely not. Void. Illegal part of contract is inseparable. We have already told it is void. When it is legal, it is valid. When it is illegal, it is invalid or void. When it is separable, valid becomes valid. When it is not separable, even valid becomes void. Are you clear? Separable or not separable, that is the only key. Separable means valid is valid. Inseparable means valid also is void. So remember this, again write it and keep. Unilateral mistake is valid. We have already told, there is no problem. Undue influence or definitely involves a moral pressure. We have already told. Mistake as to law not in force in India. Not in force in India means what? Foreign mistake. Foreign mistake is void. You already know that. What is valid? Agreement to pay time barred debt. Now here what they are saying, which of the following is not expressly declared void? Not void is valid. You know this, correct? Non-negative. Not void is valid. So agreement to pay time barred debt is valid. This is called non-negative question. So what I'm writing here, this is non-negative. Why am I writing? So that you know how a non-negative question will look like. Which parties entered a contract and a mutual mistake? Bilateral mistake is void. Are you clear? Yes. Next. When I am dominating, when one party is in position to dominate the will of another, on the weaker party, it is undue influence. I told you there is a difference. Coercion means threatening or committing to threaten. Here it is only domination. Now, stronger party is my dad. weaker party is me. So whatever he is the head of the family, we will have to abide. Now he dominates and he shows his superior position on a weaker party. What it is called undue influence. Why I am telling this example is for you to understand, because we are related, blood relationship. Coercion does not need a blood relationship at all. In coercion, physical pressure is applied. Physical pressure is applied. So that also is going to be an important factor. Next, marriage brokerage contracts are void. We already told. When the parties do not intend to perform, then that means he is doing intentionally something, fraud. Coercion, voidable. A, B, C are partners in a firm. When C retires, A and B restrict C not to do the same for 3 years. It depends on between these 3 people, because when that fellow retires, he should not do the job. So it is valid. Nobody is threatening at all. Every person is incompetent to contract when he is of sound mind, major, not disqualified. So that's the answer. So all of the above. Yes. Now, at times when I am sound, at times when I am unsound, during intervals, I can intend to contract when I am sound mind. I have already told this point. Now, fraud is again voidable. We already told this. A surgeon, employs B as an assistant for a term of 3 years, and B agrees not to practice as surgeon during these 3 years. Correct, valid, because he is very clear on what it should be done, what it should not be done. What is the majority age? 1 day after 18. 18 also will not be considered. 1 day after 18. Very important point to be remembered. So I'll better write it, put it in green color. Are you clear? Which of the following is fiduciary relationship? You know what's the answer? All of the above. Doctor, patient, master, servant, teacher, student. So it's easy to remember. So I did not give the option at all. Okay, are you clear? Shall I write this? Teacher and student, master and servant, doctor and patient. Easy to remember, so you can remember this. Yes. Next, A sells his dog during auction sale. B was the highest bidder. B purchases the dog. The dog was of unsound mind. A does not disclose. Don't you think it's fraud? Intentionally. He also knows that the dog is like that unsound mind. Intentionally fraudulent. Which of the following party can be a party to enter into contract? Is joint stock company. Company also can enter into contract. Next, a unsound person's B is liable for necessary on the BC estate. We told about the minor also. You remember? So minor and your unsound mind, all this. Silence amounts to fraud when the silence is equivalent to speech. This is direct point. Yes, we have already told this. So this and all is going to be an important one. Now this and all is we already know. This is going to be quite tricky. So I marked it in green color. A agrees to pay rupees 10 lakhs to B if B procures an employment for A. Now the point is, you get the job, I will pay you 10 lakhs. That will not be more like a valid one. So you get, then I will give. Though that will not be valid. If you are already entering into a contract and then give you some conditions that you should not work somewhere else and all is valid. This is not like that. If you get job, then I will pay 10 and all will not be like, because if he's not getting, then there should be a problem. Agrees to pay, B procures an employment. So sometimes it is not going to be a valid factor. Next point. A person who has the means of discovering the truth with ordinary diligence can avoid the contract of the ground of misrepresentation. Now, this is going to be tricky. The answer they have told here is false. Okay. When he knows ordinarily, intentionally he is in unintentionally he is not going to do. It is intention only. Correct. He also knows. So the statement is definitely false for a simple reason. He can avoid or he need not avoid the contract, depends on the situation. So this is more a tricky question. So what I would mark here is, I would mark here as the black color, because tricky question, the answer is not false. It is partly true and false. So let's not take that question. Why I am then still discussing is true or false type of questions has to be taken into consideration depending on the facts and circumstance of the case. Are you clear? So that's how it is to be. Uncertain means uncertain agreement is void. We have already told this. Next, master servant, undue influence. Two people are making a mistake, bilateral mistake. Okay. Now, boy of 21 years is entering into a contract, valid because he becomes a major. Next, A lets out a theater to B for a series of drama for certain days. The theater was completely destroyed by fire before the scheduled date. Now, what is this called? Impossibility of performance. Nobody can perform. He has agreed. A lets out theater to B. Everything is fine, but it is not under us. It is from the natural calamity. Nature, law will automatically take over the nature's perspective. Now, this is going to be impossibility of performance. Undoubtedly, yes. Next, A, B, C. Joint promise to D a sum of 90,000. Okay. So that means what? 30,000, 30,000, 30,000. C is compelled to pay the whole amount to D. Can he recover anything from A to B? Undoubtedly, yes. That's what I told. Once he pays 90,000, what is this? Very simple. A should pay 30, B should pay 30, C should pay 30. Now, if C is compelled to pay all the 90, he can take, he can only give his share as 30, recover from A 30, recover from B 30. So 90,000 he has also paid, equally also is done. So simple point. Yes, equally. Next, what is the next one? The server is employed for 1 year on a monthly salary of rupees 1,800, the whole salary to be paid. The servant wrongfully leaves the services after 6 months. Is he entitled to any salary? No, because they have told it for the whole year. So he will not be entitled. Very simple point. R contracts to sell his car to yes for 7 lakhs and yes agrees to pay on delivery. Once the car is delivered to yes and yes pays 7 lakhs, the contract comes to an end. Coming to an end, fulfilling of obligations is called discharge. So fulfilling all the obligations and contract comes to an end is called discharge of contract. Very simple. So, but I will mark this in green color because this is the first time we are studying about discharge of contract. Yes. So this meaning and all you need to be pakka. If a new contract is substituted in place of existing contract, what it is called? When it is substituted, mark this and say novation. Important. So the next one is personal violation. We wanted to don't consider this because there can be a number of points for this. Let's not bother. Next, A enters into a contract with B for dancing at his theater for 3 nights for a fee of 2 lakhs. A dances for 2 nights and is fallen ill. What remedy is available? B cannot claim damages from A. Why? Because already she is ill, so she will not be able to get. She will be paid only for 2 days, and she cannot claim any damages from. Are we clear? So simple point. Original contract need not be performed when it is all the cases. What is this? Completion of an end. All these things and all will be there. Simple point. So there is nothing to remember in this. Next, reasonable time. Reasonable time means it is a question of fact. It is not question of law. Time will always be based on fact only. So I will write here time based. Quite an important one. I'm going to mark this in green color. Y, quite a different one. X sold rice to Y by sample and Y thinking that they were old rice purchased them. But the rice is as new. In this case, Y is bound. You, because of you thinking and all, they will not change. It is actually right only. They will prove accordingly that it is correct. The right to join promises is joint and several. That means equally. Have we seen that example? See, A, B, C, 90,000, 30,000, 30,000, 30,000. That is joint and several. Are we clear? Next. X and Y contract that Y shall build a house for X for 20 lakhs. Y is ready and willing to construct the house, but X prevents him from doing so. Now, what is this point? It can be true or it can be partly false. That is the answer. So both A and B is what they will say. Next, don't bother about all this. This A and B and all, you already know the crux of it. Now, rescission of the voidable contract is communicated and revocated in the same manner as the communication of revocation of proposal. Very simple, guys. What is there offered only will be accordingly communicated for acceptance. Proposal means what? Revocation of offer only, they are talking it as proposal. So same thing. So it's not the big thing to remember. One more we will try to cover to complete this session. Suppose the time fixed for performance of contract has expired, but the time is not essential. Time is not the factor. Can I claim compensation? Definitely yes. Time is not the factor. I can claim compensation. Why I am marking the small things also in green? Because it's very new. Are we clear? So till now what we have completed? We have completed some 180 to be done. Now what we have done? We are making strong. We are doing a reverse psychology for Indian Contract Act. Now we are concentrating on the topics to be seen in MCQ, and indirectly we are covering the portions also. Now novation and all is new. A possibility or impossibility of performance is new. Unsound mind, what you can try to do. All these are new. Wagering, quasi contract, all these things and all new. So again, listen to this video and make yourself really strong so that it is always there in your head. Please write the points. Whenever I discuss the MCQ and something is important, don't just look into the video. I wanted you to write it and keep to make yourself really stronger. Are we clear? Shall we go to the next set of the classes in your MCQs of Indian Contract Act?